All right, we are live. AOS team is live to answer any questions that the community might have regarding adjustment of status. We'll wait till we can see some comments coming in, but in the meantime, why don't we introduce ourselves? America, do you want to start?
Yes, my name is America, and I am part of Dreamers Together, and I'm happy to be here. And hopefully, we have a lot of people watching, and we're able to help the community.
Great. Luisa, you want to go ahead?
Hi, my name is Luisa, and I'm one of the AOS team members, and we are here to help.
Yay. My name is Natalie, and I am also one of the caseworkers and the Adjustment of Status Department for Dreamers Together. And this is the majority of the Adjustment of Status team. And we're here today to answer any questions from our group members, from the community that may have any questions related to adjustment of status. We can hit on a few topics for you guys today. Adjustment of status generally, something maybe a little more complicated like 245I. We have some information about employment based, a little bit of everything. Oh, Jackie in the house. Okay, so we have Jackie's comment. America, you want to read it?
Says, "Hey all, just here to say hi. Thank you to each and everyone for the support and encouragement you all provide. Love you, ladies."
Thank
Oh, thank
you.
you, Jackie. Jackie's amazing. We always see her commenting on the Facebook group, and she has so much information. She's super helpful.
Gloria, to say, "Hola,
Gloria.
AOS team."
Hi, Gloria. Gloria is our amazing, amazing AP professional. She is our AP expert.
Yes,
All
she
right.
is.
I think we have a few more comments coming in. Let's see. Let's see. Are you able to click the other ones? All right.
Hi,
Hi,
ladies. Just
lady.
here to let you know you're killing it.
Thank you. Thank you. Berenice.
Berenice.
Hi, Berenice. Thank you for joining us, everyone. We really appreciate you being here and joining us on a Friday evening. We did an evening slot for the live because we do know that we have quite a few members over on the West Coast. So I know most of the California group members are probably just getting home from work. So join us, ask us your questions. We're here to help you guys out and answer any questions you might have. Erika, hi, thank you for all you do. Thank you, Erika. We appreciate you. We appreciate you. Since let's see, yep, see, there we go. People in California just getting out of work. So that's why we decided to make sure we do it nice and late so that we can accommodate everyone. East Coast can be here, West Coast can be here, and we can answer any questions. Since I don't see any questions coming in just yet, do you guys want to, do you ladies want to talk a little bit about what adjustment of status is? Maybe Luisa, you want to start?
Um, yeah, so adjustment of status is for people that, let me read this question. It says, "Hello, ladies. I am very worried because I am about to be terminated because my DACA renewal haven't arrived. What can I do?" Mini, what you can do is try to expedite. Um,
Hold on. Can we put that question back on? And then we'll move on to the next one once we're finished answering it.
okay, so
There we go.
what you can do is try to expedite your case. You can go to the USCIS webpage and expedite now for your DACA holders in this life. Please do renew early because DACA renewals are taking long, very long to renew. So do not take that chance.
Yeah, DACA renewals are definitely taking longer than what we had seen in the past. We did see some people getting them done within a couple weeks, but we always try to tell everybody in the group, make sure that you still always file 120 to 150 days before your expiration. That is what USCIS tells us to do. So we want to make sure we follow that. Now, Minnie, for you specifically, like Luisa was saying, you can definitely try to speak with Emma on the USCIS website, see if you can get an expedite in. Now, you can't just request an expedite because you want it. You have to have a valid reason. We have seen very, very few cases of DACA recipients being able to expedite a DACA renewal if they get like a letter from their employer, like HR. If your HR is willing to give you a letter, which it sounds like they may be willing to do since they are about to terminate, just saying that you're an essential member of the team, that you're very important, that if you are unable to renew your DACA in time and therefore unable to keep working there, that they're going to suffer some type of loss as a business. Talk to your supervisor, talk to your HR department, see if they're able to kind of draft you a letter hitting on those notes, and then send that in. The other thing that you should do when that happens is, we're not sure if they're going to be able to do much if you didn't apply during the correct window of time, but reach out to your Congress representatives, okay? Reach out to your Congress people. Let them know that you need their help. Let them know what's going on. That is what they're there for. They're there to assist the public. So definitely reach out to them. That's the only two things we can really give you as advice. Reach out to Congress people and see if HR is willing to do anything in order to get you a letter that you can turn into USCIS to see if they're willing to kind of push your case along, okay? Um, Other than that, if your job, if FMLA, you can maybe take leave, so they can hold your position. It's going to be unpaid, but it's a difficult situation to be in for sure. All right. Let's see. So the next question, I'll read it. Dalia says, I've seen that it's really common that officers don't take I-864W serious and they skip it. So that is true. We have seen quite a few cases where USCIS officers will hit you with an RFE even though you are eligible for I-864W and you send it and you send your proof. One thing I always say, first of all, let's start off right off the bat. Make sure you're eligible for I-864W, okay? Sometimes we log into the SSA website, Social Security Administration, and we see the beautiful green bar that says 40 credits on it, but you have to look at your earnings statement. You have to download your SSA statement, and there's going to be a chart on there that has years and wages. You have to make sure you physically count 10 years, and that those 10 years have enough wages associated with them, and that during those 10 years you had a valid employment authorization document. If you can check those three requirements off, then you're good. You're eligible to file 864W. You want to make sure you click on the right box for 864W. If you're doing it off your credits, it's going to be box 1, the very first box. And then you're going to want to make sure you send in your adequate proof. Sometimes we're not sending adequate proof. Send in your Social Security statement. Send in all the copies of your EAD cards from the very first one to the current one. And then what I like to do and what I would suggest is either on the additional information, which is the last page of that form, write out a little statement and say how it is that you're eligible. It can be very brief and very straight to the point. I have had an employment authorization document valid since blank year. Please see attached copies of my employment authorization document. I have earned 40 credits according to SSA due to my wages from this year to this year. Attached, please find my Social Security Administration statement, earnings statement. What you can also do, and what I would also suggest, is almost like if you're creating a little cover letter for that specific form, or include a paragraph in your cover letter that focuses on your eligibility for 864W. But just know that there's always a risk that you get an officer that's just not knowledgeable of 864W. But if you do, you can always try to explain it to them, almost like you're teaching them what it is. But just make sure you're eligible first. All right. Go ahead, Anna. Do you want to read that one?
You can. I-864W is only needed if the petitioner doesn't meet the required income. Is that right? You want to answer that, Natalie?
Okay. So you can do I-864W even if your petitioner does meet the required income. It would be optional, right? But if you want to avoid the risk of having a USCIS officer not know what 864W is, you can do the 864 normal if your petitioner meets the required income. Now, if your petitioner doesn't meet the required income, but you do have your 40 credits, then you should try to do 864W, or you get a joint petitioner. I'm sorry, a joint co-sponsor for the 864, or you combine your income with your petitioners if it's like a spouse based petition. So it's not that you're only allowed to do 864 if your petitioner doesn't meet it. It's just that's usually the only time where you should do it because, again, USCIS officers are more used to seeing the normal 864. So that's what we always say. If your petitioner makes enough on their own, and it's very easy to prove it using pay stubs, like their paid W-2, they make enough, you have pay stubs to send in, your best bet is probably to just to do the normal 864 because you're going to get less risk of having the USCIS officer just not know what it's talking about. All right, let's see. I see Mari. Hi, Mari.
Hi, Mari.
Sarai. Hi from Utah. Ooh, from Utah. Wow.
Ellie,
There
what's
you go.
what's AOS? I think I can answer this one. AOS
Okay.
stands for Adjustment of Status. What does this mean? It means that you can, in simple words, that you can apply for your green card in the United States if you qualify, if you meet the requirements. You can get your green card in the United States.
Can we go to, let's see, is there was one from Jose. Oh, okay, I see that's
Guzman.
AP related.
I think it's AP related, so
Yeah, that's AP related. We can maybe answer it really, really quick at the end if we have time, but we're gonna try to focus on AOS today. We do have Gabby who does AP lives every week. Oh, actually, can you do me a favor? Can you go right under Elizabeth where Minnie is? I'm a healthcare worker. Just want to touch base on that really quick. So Minnie is the one that was asking about expediting the DACA renewal. She says she's a healthcare worker. So
hmm.
that definitely is a good reason to ask for expedite. That's actually one of the few industries where the USCIS officer may actually easily expedite the renewal because you're a healthcare worker. Um, okay. Luisa, do you
Google
wanna take that
asks,
one?
yeah, it says hello from for I-485 Part 8, question 16. Have you ever worked in the United States without authorization? Has anyone answered yes to this question? Did you provide an explanation? Do you really need to get a lawyer if the answer is yes? No. You do not need to get a lawyer if the answer is yes. I'm gonna say about 85 or 90% of all applicants will say yes to this question because there are many of us that have worked without our authorization. Do not ever lie on those forms. Tell always the truth. And if you have, just answer truthfully, I have. And at the last page of each form, there's an explanation where you put the part number, the question number, and the page number, and you can explain. It can go as little as I had to work to be able to support or help my support my financially my family, or you can go and do a little bit more bigger explanation. But yes, you do have to answer truthfully to all the forms that you're sending and never lied. And no, you do not need a lawyer if you're answering yes.
If I can just add on to that one really quick, for Ugo's question about working without authorization. If we can go back to it real quick. So that one thing to note is when you're being because most adjustment of status applicants require an immediate relative petitioner. Because your U.S. citizen petitioner is your immediate relative, working without authorization is not an admissibility to adjustment of status For other kinds of applications, like if you were doing consular process, or let's say you were being petitioned by another type of family petition, if you're through another way, but if you're doing adjustment of status, it's almost always immediate relative, that's forgiven. That's why it's okay if you answered yes to that question. Like Lisa said, you can answer it how you deem fit, but when it comes to immigration, you want to be truthful, but you also don't necessarily need to give them more information than what they're asking for. So if they're just asking, did you work without authorization? You don't need to go much more in deep into it than just saying that you did or that you didn't. We have few examples in the group, but just to kind of read one off for you off the top of my head, you can put something as simple as I, if you're a DACA recipient, for example, you could put prior to my first DACA, I worked without authorization in order to afford basic necessities for myself and my family. And that is more than sufficient. You don't have to go into the details about where you worked, how long you worked, how you worked. Don't provide them what they don't need. Don't provide them what they don't already know. Just very vaguely, straight to the point, answer their question, and then that's it. All right. Let's see. All right, we have Berenice says for Form I-864, I'm putting myself down as a sponsor since my husband was a little off for the annual income. Should I also include my W-2 wage stubs? All right, Berenice, it sounds like what you're saying that you're doing is you're combining your income with your spouse petitioner, which is great. You can do that as long as you have a valid employment authorization document. So as long as you have a valid employment authorization document, you can include your income with your spouse. You're going to want to include your full annual income and then add it up on the next page. But for your proof, if you guys didn't file um, your taxes together, you're going to want to submit your most recent taxes as well. You're definitely going to want to submit your pay stubs, most recent pay stubs. Normally, I recommend your last 5 to 6 pay stubs. And then on top of that, you're going to want to include two more things: your employment authorization document to prove that you are legally working and that you can combine your income. And the last thing is, it's a little harder to get, but it's recommended whenever you're combining income. You kind of there's this additional requirement that you have to satisfy, which is that you are going to continue being employed after your green card is approved with the same employer, generally speaking, right? So in order to satisfy that income, that requirement, we usually suggest that on top of your pay stubs, you ask your employer or your HR department to give you a wage verification letter. What you're going to want to make sure that is included on that letter is that you're employed, your position, um, that your status of employment, like full time, part time, how much you get paid, so what your wage is, and then if they can add in something along the lines of they expect to keep you employed in that position or within that company, then that would satisfy that. Even if they're not willing to write that sentence, at least try to get a wage verification letter and send that in. Most of the time, USCIS isn't gonna knock it down just because you're missing that one sentence. But always ask if you can get on there. The worst they can say is no. But those are the extra things you're going to want to include: pay stubs and that wage verification letter and your EAD, your employment authorization document. All right. Let's take turns reading. Who wants to read next?
Says thank you, ladies, for taking the time to educate us and answer our questions. Diana Loredo. Elizabeth Rojas says, where can I see working credits? Elizabeth, you can go to the Social Security Administration webpage and download a statement. Usually you will see the credits. Um, and sometimes it says that you have 40 credits, but you do have to see the chart of all the years and make sure that, like Natalie said on the past answer of the questions, make sure that you do have all the requirements and that you do have a valid um, employment authorization card for all the years.
So make sure you also, just to kind of to add that in, right? You have to create an account on the website.
Oh, yeah.
So go on the website, create an account, and once you create an account, you'll be able to access the link to download your earnings statement. It should say Social Security statement, I think is what it's called. All right, Dalia Ramirez, thank you. You're welcome, Dalia. We're more than happy to help. We're happy we're able to answer your questions.
Says, hello, how can I fire an attorney? I am trying to get my money back because they were doing all the paperwork for AOS wrong. And there was a contract. I ended up doing it myself by using the guides. Natalie?
So, um, I'm glad you were able to use the guides and that you were able to take power of your application and make sure that it was being filed correctly and with the correct information. Um, if you had an issue with your attorney, you really have to look at the terms and conditions of your contract to see how it is that you have to let them know you because you do have to give them notification that you want to terminate them as your attorney. um, you do have to look at the terms conditions of how the refund is going to work. So look at your contract, read it very well. It should specify on there what happens if the contract is terminated and how they will determine how much money you get back, if any. So if they, for example, some of the common options, if you paid for a flat fee for the service, they may bill you per hour. So they may switch it to hourly billing, figure out how many hours they put into your case, and then reimburse you the difference. Other lawyers have split their payments up in like stages. So, depending on what stage you were in the process of getting your paperwork ready to file, then they may say, okay, well, we got to this stage, so you're going to get the rest refunded. And no, guys, for everyone out there that's listening, know that every single lawyer has to respond to the bar of their state, the state bar for the attorneys in their state. And all states have some type of system in place for you to submit a grievance or a complaint. So if you are unable to communicate with your attorney, or if you feel that their representation was insufficient or negligible, you can certainly submit a grievance against that attorney with that grievance commission or with the complaint commissioner, the bar of your state. Just look up your state bar complaint, and usually you'll find a link to where you can submit that grievance or complaint. Same way that we tell people all the time on the AP group, file complaints when CBP officers are not trained correctly. You can do the same for a lawyer. We're not here to bash lawyers, but we are here to hold them accountable because you do pay them for a service. They are professionals who should be educated in what they're doing, and they should be knowledgeable of policies and procedures that get updated with USCIS accordingly. That's part of their responsibility as a lawyer. So, you're definitely all in your rights to hold any attorney accountable. You can file a grievance. I would suggest that if you're going to do that, make sure all of your communication with your attorney is recorded. So through email is probably best. Written is always best, and then go forward from there. But I'm glad you were at least able to get everything done with our guides, and you were able to take power back from your case. Medium. Medium says, when my husband and I apply for the green card, only one of us shows income. My daughter is claiming us. So if your daughter is petitioning both of you, those are two separate petitions. So they're each going to be treated separately, which means your daughter, if she's working, has to show that she has enough income to support you on one petition and then to support your husband on the other petition. You don't count the other applicant on each other's petition. So that might have been a little confusing. On the application for you, medium, your daughter does not have to count your husband. She's only going to be counting you. And of course, if she has any children of her own or if she's married, she'll have to count her spouse or her children. But she's not going to count your husband because he may be applying at the same time, but his case hasn't been approved. And you're only counting people that you've petitioned before that have been approved. But it's going to be based on her income for each of you separately. So here's the thing. If each of you have DACA, and each of you want to combine your income with hers, let's say your daughter right now is a student and doesn't have any income, you each have to do that separately. So you would combine your income with hers on your application, and he would combine his income with hers on his application. I hope that makes sense. If it doesn't, leave me a comment, let me know, and we can try to explain it a different way.
Ellie, who qualifies for AOS or adjustment of status? Usually is immediate relatives of United States citizen. This means that it could be spouses, children under the age of 18, and
21.
I'm sorry,
21.
21. Oh, sorry, 21. And I say spouses, sons and daughters, and parents of U.S. citizens. So those are the people that can apply or that qualify for adjustment of status if they meet the requirements. So some of the requirements, or the most important one, is that they have a legal entry. If they have a legal entry, they can apply for adjustment of status.
Now, I just want to add on there, the exception to both of those rules is 245I. So if you have 245I, then you don't have to have a legal entry. And if you have 245I, then you don't need immediate relative, but your priority date does have to be current on the visa bulletin.
Since what Mauricio Espinosa asked, what are the requirements for the sponsor as evidence for I guess form I-864? Well, I can tell you that we start with having all the tax returns last 3 years of lack of tax returns or tax transcripts. You do have to have your check stubs, last five, previous five check stubs, and any more evidence that prove your income.
You also have to prove the petitioner status, the sponsor status. So a sponsor can only be a sponsor if they are a US citizen, a legal permanent resident, or if they are a US national. This is specifically for the I-864 form, not about petitioning you, but just for the income form. So if your main sponsor is your sponsor, then by default they're a US citizen. But if you're looking for a co-sponsor, it can be anyone. Doesn't have to be a family member. It doesn't have to be a friend. I mean, this is probably never going to happen, but it can literally be a stranger off the street if they're willing to sign for you and they're willing to give you the documents that you need to back it up. So the only requirement is their status, US citizen, legal permanent resident, or US national, and then their income. Well, there's a third requirement, which is they have to be living in the US and their income has to be legal in nature. So they just have to be earning their income legally. Okay, I'll
Ellie
handle this one.
asks, Ellie
Okay,
asks, can my
go
employer
ahead.
petition me for AOS? I got DACA at 19 and did AP. If you got DACA at 19, I think that you had any uh, accrual presence
Mhm.
in the United States between 18 and 19, and that will make you ineligible for your employer petition, for the
Just
employer
to
to
go a
petition you.
little, just to go a little more in depth into this one. So first off the bat, one thing that I always like to mention for anybody that's thinking about an employment-based petition, advanced parole is irrelevant. Doesn't matter if you did AP or you have or you haven't done AP. AP is of zero benefit to a DACA recipient when it comes to an employment-based petition. Um, how you entered, even if you came originally with a legal entry, that's still kind of really irrelevant for an employment-based petition for adjustment of status. The only people that are DACA recipients that can do adjustment of status on an employment-based petition are those who have 245I. There is no other way around it. The reason being is the biggest hurdle is that for employment-based petition, you had to have been in the US with some type of legal status the entire time in order to be eligible for adjustment of status through employment. 245I is the only way to get that forgiven. It forgives you not having legal status the entire time. Now, there's still the possibility of doing adjustment of not adjustment of status. There's still the possibility of doing consular processing. through an employment-based petition. But for that, that's what Lisa was talking about. You have to know how much unlawful presence you have accumulated. One thing that's important to know is that you start accumulating unlawful presence in the US when you turn 18, and it stops whenever you have some type of protection like DACA. So, for those lucky few that got DACA before they turned 18, and they've never missed a renewal, which means their renewals have always been on time. So you've never had a gap in between your renewals. You have 0 days of unlawful presence. So that means employment based consular processing is a possibility for you. For anybody who has more than 180 days, so the max is 179. You have 179 days or less of unlawful presence, employment based is possible, but it has to be consular processing unless you have 245I. Okay, I know that was a lot, but that's kind of how it goes with employment based. Let's go on to the next one. Ame, you want to read that one?
Natalia Ramirez, a spouse-based petition. He doesn't meet the requirements. No other sponsor I can think of, lol. But I made enough for 2 people household. Can I just put my income? Last question, I promise. And I believe Natalie answered this before, but yes, you can combine your household income if your sponsor or your spouse, whoever is petitioning for you, does not meet the required income.
Mm-hmm. And guys, just to kind of add on there, even if your spouse's income is zero, zero is still a number. So if your income on its own is enough, you can add however much you make to whatever they make. If that amount is zero, zero plus whatever you make is still whatever you make. So you can still do the combined household income. Um, we have a YouTube tutorial on YouTube, of course. We have a tutorial on YouTube for the 864 form. Briefly, we touch on combining income, but we're hoping to make another tutorial soon where we talk a little more in depth about how to fill out the 864 of your combined income. But it's not difficult. Right under where you would put your petitioner's income, right underneath that, it says person one. That's where you're going to put your name or your relationship and your income level. And then you just add those two incomes together on the next page and you put down, you mark off the little box that says that you are the beneficiary or the intending immigrant, and then you write your name. And then you just provide your income proof that we talked about a little earlier in the other question.
Can I switch from consular process to AOS? Will it affect me negatively in any way if I switch? It will not affect you if you switch. We encourage everybody that can apply for adjustment of status to just do it here and don't take any risk or going outside and staying out there.
Now, I want to add to that. Please do remember that you have to go out with an AP. You cannot adjust without having a legal entry. Usually, whoever does consular is because they do not enter with a visa, um, they have a entry without. Do remember that you have to have a legal entry to be able to do AOS. Hola, voy a hacer EOS a través de mi hijo ciudadano, pero él solo hizo 23.700 en el 2022 y me dijeron que no es suficiente, entonces necesito un co-sponsor. ¿Qué documentos necesito del co-sponsor? Del co-sponsor necesitas llenar otra aplicación de co-sponsoring, de la I-864. Necesitas otra vez prueba de que es ciudadano residente de Estados Unidos. Necesitas los income tax de los pasados 3 años. Si tienen los tax transcripts, serían mucho mejor. Debes de tener los últimos 5 pay stubs de tu co-sponsor y que pues ellos sean elegibles para poder sumar a lo que hace tu hijo. Hola, felicidades por el excelente trabajo que hace. Gracias.
Gracias, María. I'll read this one. Caleb says, sorry if this was answered. I just joined. I filed for AOS. U.S. citizen sponsoring DACA spouse after DACA spouse did AP. Good job, AP. What is the time frame typical for this type of AOS? The shortest time for approvals and the longest time for approvals. Just trying to get an idea on how long it can take. Okay, so first thing to start off, a little disclaimer. We can give you estimates of what we've seen, but based off USCIS, they will always say that you're within processing time frame, as long as you're within like 3 or 4 years, basically. Sometimes maybe 2 years. What you're gonna do is you're gonna basically go to their website and pull up the service center that is handling your case, which is the one that'll show up on the bottom left hand corner of any receipts that you get. And then you'll go there and you'll put what kind of application you have, and they'll tell you how long, how many months is the average processing time. Now, that is an average processing time according to them. Now, what I can tell you from our experience as caseworkers, watching, and communicating with group members in our group is that normally we're seeing anywhere normally before this year, we were seeing average times of about 12 to 18 months. That's about a year to a year and a half. That was the normal average processing time from what we could see for a US citizen petitioning a spouse with a legal entry. Now, something happened towards the end of last year. And basically, almost everyone that applied um, December of last year or January of this year started seeing much faster processing times. We have seen as fast as right under 60 days, which is crazy. Honestly, to me, that is crazy to get you filed your receipt date and your approval date is less than 60 days apart. That's crazy, but it is possible. It has happened and it's evidenced in our group. But we have also seen a lot more people being processed within 6 months or under 6 months. So somehow something happened there with USCIS. I can give you kind of like what I think happened. They implemented a new system as to how they're processing applications. And so instead of working the old ones first and then the new ones, they seem to be working the new ones and trying to get them out the door as quickly as possible. What has also helped out a lot is that they're really trying to waive as many people's interviews as possible, and they've even finally gotten they finally gotten on board with us, and they finally started telling applicants to submit their medical exams with their adjustment of status. So all of those things put together has turned into much faster processing times. I would say right now the average that we're seeing for anyone that filed after December of 2022 is going to be about 6 to 9 months roughly. You may see cases go a lot faster than that. Anybody that filed before December of 2022, I am still seeing an average wait time of about 12 to 18 months. So I know we have a few group members out there that filed before then and they're already at 12 months or past that. I think unfortunately they're still using their old method of processing for those cases, and that's why you're seeing a little bit of a longer wait time there. But Caleb, if you just filed this year, I would say probably going to be anywhere between 6 to 9 months, my personal estimate, from what we've been seeing in group members. I think probably Luis and America, I don't know if you guys would agree with that.
I do. I do agree with that.
Absolutely. I always say that's the $1 million question. If we could only have a perfect answer for that.
Silvia Martínez dice, quiero hacer, hacer mi EOS por mi hija. Ella ya está trabajando y por lo que vi calificamos, pero yo al momento estoy trabajando, pero me pagan en cash, eso será un problema. Si tu hija trabaja hace 3 años y este año eh, tiene lo suficiente, no veo por qué haya problema porque el sponsor va a ser tu hija. Em, entonces no veo que haya problema. Lo mismo que he dicho anteriormente, ella tendría que incluir sus pay stubs, los últimos 6 pay stubs y los últimos tax returns, la información de los últimos tax returns, de los últimos 3 años. Ahora, si tu hija no gana lo suficiente, em,
Joint sponsor.
lo más fácil sí sería conseguir un joint sponsor, porque aunque tengas y tú hagas tus income taxes y reportes tu cash income, no hay forma de probar lo que estás ganando en este momento.
Mhm. Correcto. Okay, so Elizabeth asks, are you lawyers? And the answer to that question is no. None of us three here today are lawyers, but I will caveat that with this. We all work with Dreamers Together. Dreamers Together is a recognized, acknowledged organization. What that means is that Dreamers Together has gone through the very lengthy um, process of getting recognized and acknowledged by the Department of Justice, um, the Department of Justice, and OLAC, so that they can legally be allowed to prepare and represent um, immigrants with USCIS. Um, Partnered with that recognition, our staff is accredited we are accredited representatives. Specifically, our CO is an accredited representative. Our admin teams are accredited representatives. I'm on the AOS department. I'm an accredited representative. So we are legally allowed to give you advice. We're legally allowed to prepare your forms, and we represent you with USCIS. So we're not just your run of the mill where people go, oh, I went to a notario or I went to a paralegal who filled out my paperwork. No, what they're doing is not legal. They are not allowed to fill out your paperwork for you. They're not allowed to advise you on how to move forward with USCIS. And they're not even allowed to tell USCIS that they prepared your paperwork. So we are. When you do something with us, when we take on your case, you're going to see that we fill out something called a G28. And a G28 can only be filled out by a lawyer who is representing you or an accredited representative who is representing you. And USCIS will attach our names and our accreditation to your applications. So we would be able to represent you the same way that a lawyer does. And that's why we're here trying to provide you the correct information. On top of that, Luisa and America um, have both had years of experience working in immigration related items as paralegals. So they do have sufficient acknowledge in order to be able to give you the information. But on top of that, I mean, the information that we're providing you today is publicly available information. This is all pieces of information that you can get directly from USCIS. You just have to do the research. You can get it directly from reading the INA code, the Immigration Nationality Act, and then you'll be able to get all the information that we're giving you. You'll be able to see that it's coming directly from law and it's coming directly from USCIS. But just wanted to throw that out there. Streamers Together is a recognized and acknowledged organization, and our team is accredited representatives. And there is always going to be an accredited representative that is going to be signing your forms, reviewing your packet before we go ahead and release it to you, before we go ahead and prepare anything for you. It is an accredited representative that's going to be looking and handling that case. Okay. That's a great question, though. Okay.
I
Go ahead. Dale.
I think we already responded that question.
Oh, yeah, we know we did. Stephanie says, I do have my 40 credits, but I do not have an income this year. Will that be a problem? My petitioner is my husband, which he's self-employed with 1099 for 2022 taxes. Past years, he's filed with his ex-wife. Should I find a sponsor or submit 864W? That's gonna be that's gonna be a personal decision that you're gonna have to make. Now, you say you have your 40 credits, you're currently not working. That's okay if you've truly earned your 40 credits. And the reason I say truly is because what like we've spoken before, don't just base it off of what the Social Security website says and that pretty green bar that says 40 credits. Make sure you check your earning statement. So Stephanie, if you check your earning statement, you see your 10 years, you see that the wages on each of those years is sufficient, and you've had a valid employment authorization document during those entire 10 years, then whether you keep working from here moving forward is irrelevant. You have your credits, you are eligible for 864W. Just to give yourself the best shot, I would say if that's the route that you're going to take, make sure you follow what we've given as tips. Make sure you include all of the necessary proof, your statement of earnings, all of your EAD or your work permits copies, and include some type of explanation. My philosophy, and I tell this to all of our cases and my clients as well, is we want to make the job as easy as possible for the USCIS officer that's handling your case. The easier we make it for them, the easier of a time they're going to have adjudicating your case. And hopefully that means the faster you're going to get your case approved. So make it as easy as possible for that USCIS officer. Don't make them have to find out how you're eligible. Tell them straight directly how you're eligible. My name is Stephanie. I have earned my 40 credits, which is evidenced by my earning statement. On the earning statement, you will see the 10 years in which I earned the 40 credits. And I have also attached copies of all my work permits that are valid and that I used during those 10 years. You've gone ahead and you've told them how you qualify, you told them how you're eligible, and you've told them what proof you've submitted. With that, you really shouldn't have much issue with the 864W. But even if you do, even if for some weird reason the USCIS officer just really does not have any idea what they're doing or what they're talking about, and they still hit you with an RFE, at that point, you have an opportunity to then look for a co-sponsor. So you definitely will have an opportunity. They're not going to outright deny you and say, okay, your 864W is out the window, denied. They're going to send you an RFE. They're going to give you some time for you to respond. And that's the time that you have to kind of reach out, see if you have, anybody that's willing to be a joint sponsor for you. They fill out their form, you respond to the RFE, and it's taken care of. Crystal says, how can I book an appointment with y'all? I'm so happy you asked. We still have I do believe we still have some consultations available, which is actually a very rare occurrence for us. And I think it's because our appointments got fully booked really, really quickly. So what we did is we went ahead and we opened up a few more for everyone because we know that people were wanting to book and had reached out and told us that there wasn't any slots left. So what you can do, easiest way that you can book with us, go to our website, dreamerstogether.org. Click on the tab that says services, and then you're going to click on AOS adjustment status, and there's going to be a button that says book now. If you click on that book now button, it's going to take you straight to our calendars and our available appointments. The other thing that you can do if you want to go straight to that calendar or those appointments is you can go to www.calendly.com/D2G hyphen AOS. Again, that is www.calendly, calendly.com/D2G hyphen AOS. And we're going to go ahead and if you are on our Facebook groups, I mean, we've posted it there several times. It's in our featured post. But you can always text us. You see that number that is on these lovely ladies' heads right there, 203-437-7566. You can always shoot us a quick text or give us a quick call during our business hours, and we will send you the link. Let us know what kind of appointment you're looking for. You're looking for AOS, shoot us a text, say, hey, I want to book an AOS appointment. We'll send you the link so you can book. I know this is about AOS, but if you need help with AP, you need help with your DACA renewal, same thing. Send us a text to that number. Say what you need. I need a DACA appointment. I'm trying to reach out to you guys because I need help with my AP. We'll send you the link so that you can book. All right. We have plenty of spots available. We're trying to open them all the time so we can help as many of you as possible. CEO is in the house. Hi, Vanessa. All right, let's see here. Osvaldo says, can I adjust my status if I have a visa number available on an approved family-based I-130? The visa bulletin states that my priority date falls within the adjustment of status window, and I'm waiting to hear about my AP application. Osvaldo, give me a few more chunks of information there. What is your category there? Because you're talking about the visa bulletin, which makes me think that you're in a family preference category, which means you don't have an immediate relative petitioner. So that means even if your visa bulletin states that your priority date is within this window for adjustment of status, remember that you have to overcome the admissibility for adjustment of status. And the biggest one to overcome there is that you have to be in lawful status in order to adjust status. That is for everyone. The exception is if your petitioner is your immediate relative. So if your petitioner is your US citizen spouse or your US citizen child over 21, or if you are under 21 and it's your US citizen parent, then you would be able to you be able to waive that requirement that you be in legal status in order to adjust status. So I'm thinking you probably have one of those family preference visas, F21, F2B, F2A, maybe one of those. Now, the exception to everything that I just mentioned, Osvaldo, is if you are grandfathered under 245I. So let us know if that is your case in the comments, and then we'll be able to provide you more details. Oh, Danny says, thank you so much. You are all amazing. Oh, you're welcome, Danny. We love being here, being able to answer your questions, and we hope to make this a regular thing and do this once a month, right, ladies?
Yes.
Hopefully.
Okay, so I have to show my own income since my daughter has no income. And then she follows with, I don't have DACA. So if you have no legal employment or you cannot prove that you legally earned that money, you cannot add your own income. You will have to join find a co-sponsor.
Yep, that is right.
Jennifer Diaz
Jennifer,
said,
go ahead, go ahead.
no, go
Dale.
ahead.
Okay, okay. Jennifer says, ladies, I have 40 credits, but unfortunately I didn't make enough for 2013. How soon will the Social Security table update for 2023? I'm hoping to file AOS January 2024 and file I-864W if possible. Um, so Jennifer, that is a question that we unfortunately can't answer for you. That is handled by the Social Security Administration as and the IRS, because Social Security Administration gets information kind of from the IRS. It has to do with your wages that are paid into Social Security each month or each paycheck. Last year, they didn't update it until about, I think it was April or May. And by last year, I mean this year. This year, they didn't update it until about April or May. So if you're hoping to do 864W, you may be kind of, you know, it may be, kind of going with the flow a little bit. Like you're gonna have to kind of check in every once in a while on the Social Security website and see once it updates. There is a possibility where you can send your Social Security earning statement and send your W-2 for 2023 that shows your Social Security wages on there. And you can try to give a very well written letter explaining how the Social Security Administration has not yet updated your earnings statement, but this is your W-2 in lieu of that year that's missing. I'm not sure if it's just there's not a way for us to tell you that that's going to work because we don't know what kind of officer you're going to get. You may get an officer that's very well versed on the accumulation of credits with SSA, with the Social Administration, and they may look at it and say, oh, it's so obvious that she got her 4 credits this year because look at her wages. And then you may get an officer that isn't aware or doesn't care enough to take the time to calculate it, right? They're not, and here's the thing, they're not required to calculate it. They're not required to do any work on their end to see that you made the credits. That burden of proof lies on you as the applicant. So I don't know. If I had a spouse or if my petitioner did make enough money, I would just go down that route. But if you're married to the idea of doing 864W, you may just have to kind of have your application on hold until you see that update. It's definitely going to update next year. It definitely normally doesn't update right away in January. So I would say we're looking at anywhere between February and May for them to be updating it.
Miriam Tay says thank you. And
You're
this is a
welcome.
random one, but it is very important, so I picked it out.
Go ahead.
Okay, guys, random question. It's GMT, first time traveling through a checkpoint in Las Cruces, New Mexico. What do I say? American citizen, or do I just say no and show my DACA card? Just nervous since I'm going alone. Never claim to be a U.S. citizen. Do you want to add anything, Natalie?
That is the most important piece. Never. If they ask, are you American citizen? No. Answer truthfully. No, I am not an American citizen. I am a DACA recipient. Here's my employment authorization card. That's what I would do. If I'm going through a place that I know there's a checkpoint, I'm going to keep my employment authorization document somewhere really, really accessible. And then if I see them up front coming up, I'm going to have it in my hand ready to go. And when they ask me, are you a US citizen? No, I am not. I am a DACA recipient. Here's my employment authorization card. Just get it out of the way right away. Right away. Know that with your valid employment authorization document, you are protected under DACA. So I know you're nervous, but take it easy. You're going to be fine. You have a valid employment authorization document. Obviously, please make sure you're not doing anything, transporting anything, or you're going to have anything on your person that's going to cause you to get in trouble. That is very important. Even if you have DACA, you have to make sure that you are abiding by legal rules. So make sure. I'm not saying you're going to carry anything. What I'm saying is sometimes we let other people ride in our cars and we don't know what they have brought into our car, on their person. We don't know what they have on them that may have fallen. It could be something it could be an illegal substance. It could be an illegal item, like, certain things like certain kind of things like switch knives are illegal in certain places. So just make sure. What I would do is, if anybody has been riding in my car recently, I'd give my car a quick once over and just make sure there's nothing in there that shouldn't be in there. And then I would keep all of my documents handy and accessible for when I go through that checkpoint. Other than that, though, you should be fine. Okay. All right. Do you, either of you ladies want to take that one? No? Okay. I'll take this one. Okay. So Elizabeth says, ¿Qué es 245I? O 245I. So I'm going to answer this one in both languages. So 245I is a law that many people are grandfathered. Sometimes they don't know. What 245I is, it is a special exemption that allows you to um, be eligible for adjustment of status, even if you don't have a legal entry, even if you're not currently and were never in legal status in the US, and even if your petitioner is not an immediate relative. Um, it will still allow you to adjust status once your um, priority date is current on the visa bulletin. In order to be eligible for 245I, or to have 245I grandfathering, you must have been petitioned before or by April 30th of 2001. Someone must have submitted a petition for you, either a family-based petition, so someone submitted an I-130 for you, or an employer petition for you and submitted an I-140 for you, or an employer requested a labor certificate for you and applied to the Department of Labor for a labor certificate for you. Now, I know this whole time I've been saying you, like they had to have applied for you, but you can also be a grandfathered derivative. What that means is that instead of applying for you, they applied for your parent. And at that time, you were under 21. Okay. Or they applied for your spouse. And at that time, you were married to that person. So, quick scenarios. Fulanita. Fulanita is 5 years old in 2000, and her father was petitioned by his employer. But Fulanita's father's employer went ahead and submitted a labor certificate application with the Department of Labor for her father. That happened back in 2000, right? Years have gone by. We're in 2023, and Fulanita is married to a legal permanent resident. And she has an I-130 that's approved, and her visa bulletin is priority date is current. She can use the 245I from her father to adjust status in the US. Because she was under 21 when her father was petitioned, her father is grandfathered and she's grandfathered as his derivative. You just have to prove that connection. Same thing, Fulanita, let's say, was older and she was married to Jose. And Jose's brother is a US citizen, and Jose's brother petitioned for Jose, right? Jose was married to Fulanita at that time. So Fulanita is grandfathered from that petition, even if she's no longer with Jose today. So even if she divorced Jose 5 years ago, she's still grandfathered because at the time of the petition, she was married to him. All right. So it's really important for everyone out there that's listening today. Check for yourself, check for your family members who may not have DACA and the ability to get AP. Check if any of you are grandfathered under 245I. First things you should ask is, has anyone petitioned for me before April 30th to 2001? Anyone, a family member or an employer? No? Okay. Was I under 21 at that time? Yes, I was. Did anyone petition for either of my parents back then? That's the next question. Ask your parents, talk to them. Sometimes you find out that somebody applied for them that many years ago and they never talked about it because it never went anywhere. But through FOIAs, you can find that information, and now all of a sudden you're grandfathered under 245I, and you have a lot more possibilities to get a green card. Okay, so ask your parents, and if you're still married to them or you're still on good terms with them, ask your spouses from that time. If you weren't petitioned directly, ask those two sets of people and see if someone anywhere petitioned for them. You may be very well be grandfathered under 245I. Oh, en español. I'm so sorry. 245I es la ley que permite de que usted haga ajuste de estatus, aunque no tenga entrada legal, aunque no tenga un patrocinador que es un ciudadano directo como su pareja o cónyuge o su hijo mayor de 21 y aunque no tenga estatus temporal legal en los Estados Unidos. La manera que usted sabe si tiene la protección de 245I es que si alguien aplicó por usted, más tardar el 30 de abril del 2001, ¿ok? Y cuando digo alguien, un familiar tiene que haber sometido un I-130 por usted, o un empleador tiene que haber sometido o un I-140 o un certificado de labores con el Departamento de Labor. Cualquiera de esas tres cosas, aunque se hizo más tardar el 30 de abril del 2001. Ahora sigo diciendo usted, pero si nadie aplicó por usted en ese instante, pero alguien aplicó por sus padres y en ese momento usted era menor de 21, usted también tiene la 245I de protección como una derivada. So, por ejemplo, si usted en el 2000 tenía 5 años y el empleador de su papá lo pidió a él antes de abril de 2001, su papá está protegido debajo 245I. Y como la hija de él y menor de 21 en ese momento, usted también está protegida debajo de 245I. La otra situación es que si usted en ese instante, en el 2000, digamos, era mayor de edad y estaba casada, y digamos que el hermano de su pareja pidió a su hermano, usted está protegida debajo 245I por simplemente haber sido casada con la persona que recibió esa petición, aunque usted no siga casada con esa persona hoy en día. Ok, eso es importante siempre preguntarse usted mismo, ¿alguien me pidió a mí antes del 30 de abril del 2001? ¿No? Ok, ¿alguien pidió a mis padres o a mi cónyuge en ese instante o en ese tiempo antes del 30 de abril del 2001? Eso es lo primero que tiene que hacer. Si alguien sí fue pedido, hay que empezar el proceso de pedir los records de UCIS, de hacer los FOIAs para tratar de conseguir el comprobante y usar la 245I.
Natalie, quiero let's get this point out. It's only fathers and cónyuges, right? Solamente son los padres y los esposos o esposas.
Correcto,
No cuenta si eres
correcto.
hermana, cuñada,
Mm,
tía,
mm. No
abuelo.
importa, la persona que te pidió puede haber sido tu hermana, cualquier persona que califica para un 130. Pero si tú estás tratando de recibir la protección a través de ser una derivada, la persona que fue aplicada tiene que ser o tu padre o madre, y tú eras menor de 21 en ese momento, o tu cónyuge y ustedes estaban legalmente casados en ese momento. ¿Ok? So, esa es la única persona por cual tú puedes recibir la 245 ahí indirectamente. O sea, que no te pidieron a ti, pero pidieron a esa persona y usted tenía esa relación calificada con esa persona. Stephanie says on Form I-485, page 14, question 68A, which is the public charge section, have you ever received supplementary Social Security income SSI? Should I put no? I do receive Medicaid, FAFSA financial aid, unemployment counts. Okay, Stephanie. So really quick, Medicaid. You aren't eligible for Medicaid if you're not a you're not a legal generally if you're not a legal permanent resident for at least 5 years or you're not a US citizen. Did you maybe receive emergency medical, which is slightly different? Um, but either way, I highly doubt you received Medicaid. Maybe you received it for your kids, or emergency medical. That doesn't count towards public charge either way. That's not SSI either way. FAFSA financial aid is also not SSI. FAFSA is also something else that you're required to be a legal permanent resident or a US citizen to receive. So I'm not sure how that's working out for you. Maybe you can give us a little more information. And then unemployment definitely does not count as supplemental Social Security income. We pay into unemployment every time they take it out of our pay stubs. Our employer pays into unemployment for us with the state. So when you receive unemployment, it's not a type of aid or welfare or anything like that, or a cash benefit. You're literally just getting back what you've already paid into it. Hugo Gasca. Do we have to file I-765 worksheet with the I-765? Not when you're applying under adjustment of status, just the I-765 itself.
It says, I have a question. My husband and I got married August 2023. He is a US citizen. We will be filing married filing separately. Also, because our jobs, we are not living together, but spend some time often. Is that a red flag, or what else can we show to prove that we have a genuine marriage? Um, I would say that this is a red flag. Um, because what USCIS looks for is that you are sharing an address or that you are living together. And the second thing that they look at is your taxes, that you are filing taxes together, and that you do have your financials together. Um, it might raise a red flag, and they might RFE you or ask you for an interview if you don't have any other options. But we do suggest that you do file married, family jointly, and that you do have the same address where you guys live. I don't know if Natalie wants to add something to it.
Yeah. So I'm gonna add red flag in the sense that your application may undergo more scrutiny, is what I'm going to say.
Mhm.
None of these items are things that are going to outright make you ineligible for your adjustment or deny your adjustment. You just want to make sure that you're sending in really strong proof. Um, how you file your taxes, can they question why you're filing separate instead of together? Yes, but for many people, it's financial reasons. Like it makes more sense financially to file separate. Like, for example, if you each make a lot of income on your own, or one of you has like a your own business, sometimes that makes more sense to file separately. Just make sure you're either filing jointly or married filing separately. You cannot file as head of household. It's not your situation, but you should be fine. But the fact that you're not living together is one that's definitely going to cause a little more scrutiny. What that means is, like I said, just want to make sure you're sending a really strong packet. Don't try to avoid the subject, hit it directly on. Yes, we're filing separately. Here's why. Um, that one you may not have to explain too much why, but mostly the not living together. Yes, we're not living together. Here's the reason why. Because of our jobs. You can provide explanations on your paperwork, guys. That's what that additional information section is for. You can also include a brief explanation in your cover letter. That's fine. That's where you want to explain things. If your case has something that's a little strange, a little off, something you know is going to cause further scrutiny, just face it head on, mention it in the cover letter. Um, we are currently not residing together due to our employment. My employment is in this state, his employment is in this state. What you're going to want to do is show proof that you've been visiting each other, right? We don't live together, but we visit each other at least, 2 to 3 times a month. Show that. Show your itinerary. Either you drive to see each other, or are you flying to see each other, or you're, taking a train to each other. That's perfect. Make sure that even though you're not filing your taxes together, hit that head on by showing lots of proof of financial commingling. So, do we have bank accounts together that we both contribute to? Do we have savings account together that we both contribute to? Do we have retirement accounts where we are each listed as each other's beneficiaries? Insurance is a great method of showing combined finances as well. If neither of you have a life insurance, highly suggest that you each get one and you list each other as beneficiaries. Life insurance is a great way to show that you're committed to that other person. Um, make sure you're listed, like I said, list each other as beneficiaries on anything and everything that you have: stocks, bonds, IRAs, 401ks, life insurance. You're definitely going to want to put in that extra work to show that you have a bona fide marriage with a lot of financial documents, and a lot of visiting each other because you're not living together. But like I said, just hit it, hit it straight on, hit it right in the head. Let them know straight up, yes, I do. I am aware that this is something that is not normal, but here is the reason why we're in this situation. And then you should be fine. Do know that though, with that situation happening, the combination of filing separate and not living together, you are going to be at, the higher end of the probability of getting an interview, like Luisa says. So just be prepared for that. How long does it take to get case from NVC to local USCIS office for DACA to AOS? It's really up to USCIS. They're going to adjudicate your case while they're waiting for NVC to send it to you, to send it to them. So it's not really going to cause a delay per se. But there's really no way for us to tell you how long it takes. It depends on the officer. The officer can request NVC to send your case file over in the beginning of the process, or they can wait toward the end. They can pressure NVC as much as they feel like they want to pressure NVC. So there's really, wish I had an answer for you, but for this one, that's just one of those that we really have no way of knowing. Doesn't really cause or seem to cause people's cases to slow down. We have plenty of people who switch from consular to AOS, and they really have the same time frames as people who haven't switched, who just started AOS from the beginning.
Okay, says Dina Perez says, don't answer this if this question is not appropriate for this Q&A. Helping my dad to get his AOS, but first he's going to get his PIP. Have requested his FOIA, but it's been over 2 months and have not heard back. He tried entering the US at least 3 times in the same years back in 1999. Third time was he was able to cross. Wondering it, we should still wait for the FOIA. He has no records outside of those attempt entries and entry, and he also qualifies for a visa U. We will be getting a lawyer for that process, and the comment cut off. uh, I do think that you no, definitely not think. You do definitely need to wait for that FOIA to come back and see how many entries he has, because if he has more than one entry, which is the initial entry, then he will have a bar. Now, if he applies for that visa U, usually the waiver that the visa U does usually forgets everything except, I think, it's fraud. So I would suggest for you to wait for that FOIA to get back. I don't know if Natalie has something else to do or to say on that.
uh, I'm just going to add on here that you said he tried entering the US 3 times. Um, so here's the thing that I want to mention out there. There is a difference between entering and attempting to enter the US. And it's all about how the CBP officer that, parentheses, caught you, um, it processed it. There's something legally called a voluntary return, colloquially it's called a turnaround or a throwback. So basically, what that is when you're caught trying to enter the country without inspection, and the CBP officer basically stops you, and they basically just tell you, sometimes they take your fingerprints, but after they take your fingerprints and your picture, they basically just tell you, go back, go back. You're trying to enter illegally, just go back. And that's it. And if that's what happened to your father, then that's a voluntary return. Voluntary returns are not considered entries. Okay, they're considered turnarounds, turnbacks. They're not considered entries, which means if the two times that he attempted to enter were both like that, then the only entry that actually happened was the third one. Now, if your father, when he was caught by CBP, he underwent the fingerprints and was held for a while and then was made to sign several documents, or if he remembers them telling him, you can't try to return for the next 3 or 5 or whatever number of years, and then he was actually given a few set of documents to take with him, then that is considered an expedited removal. And that's different because for that one, that's technically a type of deportation. So that means you entered and they removed you, they deported you, but it's expedited. I will say, back in 1999, CBP officers, they tended to do the voluntary returns because that didn't require them to do paperwork. And they didn't want to do paperwork. So for most of the time when they caught people, they would just fingerprint them, they would take a quick picture if they had to, and then they tell them to turn around to go back. So that only required them to file one piece of paper instead of filing a whole bunch for the expedited removal. But you definitely, like Luisa said, you're going to want to wait for that CBP. Actually, I don't know what kind of FOIA requested, but if you requested a CBP FOIA, they do take a little longer. It's well worth the wait. If you didn't request a CBP FOIA, definitely request one now so that you can get your FOIA request in there. And I would suggest that he also request a OBIM FOIA, Office of Biometric Identity Management or Information Management. What he's going to want to do for that is you're going to want to go somewhere that can fingerprint you. Um, you can go somewhere private like I don't know, like a FedEx or UPS office that offers it and have them fingerprint you. If you don't feel comfortable going somewhere, you can fingerprint him yourself. You just have to read the instructions and buy like an ink fingerprinting kit. You can get them off Amazon, to be honest. But you're going to need fingerprints. You're going to scan those fingerprints into the FOIA request, and then you're going to need a piece of paper that he has to sign. And that piece of paper is available on our group in the files tab. It's on there. It says OBIM FOIA paperwork or whatever. I don't remember the name off the top of my head, but it's there. Print it out, fill it out, have them sign it, and you upload both of those two items to the OBIM FOIA request. Where do you do an OBIM FOIA request? You go to www.securerelease.us www.securerelease.us, and you can create an account and you can go ahead and submit a FOIA. It's going to be under the Department of Homeland Security, and then under that, it's going to be OBIM, Office of Biometric Information Management or Identity Management, something like that. But you're going to fill that out and you're going to upload both those documents there and hope to get a response back. Uh, if you haven't filed a CBP, or if somebody filed a CBP FOIA for you and you're not sure where to get those results, you can also file the CBP FOIA on that same website, www.securerelease.us. If you go to our YouTube and you search Dreamers Together FOIA workshop, we have a workshop where we showed you step by step how to do the CBP FOIA request. So you can definitely do that as well.
Says
Elizabeth says, go ahead.
Elizabeth says, my lawyer said I can do AOS with my daughter, but I don't have a legal entry. If you do not have a legal entry, you cannot do adjustment of status. You can do consular process, but you cannot do adjustment of status unless you have something that will grandfather you in with that 245I, or that you came in with a visa. But
Yeah. I will say one thing really quick, and this everything Lisa just said is 100% correct. Here's my thing. If that lawyer is telling you, no, for sure you can do it. You can do it. I have this many cases. Look at all these cases that I did, and the person didn't have a legal entry and their daughter petitioned for them. Red flag. Red flag. Make sure you ask that lawyer, can I see the form that you will be what form will you be using for my application? And if you see that they're submitting an I-360, get away from that lawyer. They are doing fraud. What they are doing, super, super common right now, a lot of people are getting in trouble for it. People are getting their green cards revoked. People who did it this way got their green cards, their lawyer got caught, and now those people who had those green cards are getting their green cards taken away, and some of them are being sent NTAs, which are notices to appear with immigration court. Okay. This is something very prevalent. This is why I'm talking about it. It's like something I'm pretty passionate about right now because I'm seeing a lot of it, and it bothers me that I see our community taken advantage of. What they're doing is filing a type of VAWA. VAWA petitions are when you are being battered um, or cruelly or suffering extreme cruelty. So what they're doing is they're telling immigration that your daughter is battering you, abusing you, and that you are suffering extreme cruelty due to your daughter. Now, are there cases where that is legitimate? Yes, there are cases where parents, unfortunately, are abused by their US citizen children. But if that's not the case for you, then all that's happening is that lawyer is putting you at risk by filing a fraudulent case. So, any lawyer that tells you you don't need a legal entry for your daughter to do adjustment of status for you, you don't need a legal entry at all, ask them more questions. What are you applying for? What is the form? Can you show me the form? When you go to sign the paperwork that they're filling out for you, look at the form that you're signing. Read it. Ask them what kind of evidence they're needing from you, and be very, very aware of what kind of case they're presenting on your behalf. Okay. If you are being petitioned by your daughter and you are undocumented, you need a legal entry, whether that be 245I that waives it, whether that be you overstayed a visa, whether that be you have AP, whether that be your child's in the military and got you parole in place, but you need some type of legal entry. If you, the only way to avoid that is a VAWA case, and a VAWA case has to be legitimate. Don't let people file fraudulent cases for you, please. They're putting you at risk when all they have to lose is their money and maybe their ability to be a lawyer, but you're putting your ability to stay in the US at risk. Okay.
María says, cuando aplicas para AOS, ¿tienes que aplicar para la Combo Card para salir de USA o solo con la Green Card puedes salir? Eh, Puedes aplicar para la Combo, bueno, la Combo Card son dos formas, que es la I-765 y la I-31, la I-3, ¿cómo es?
131.
131. Esa forma, son dos formas y pueden que te manden un combo card, que es el permiso de trabajo, donde dice abajo que está autorizado para viajar. Puede que te manden una hoja. No, no siempre es un combo card. Queremos dejar esto bien claro porque a veces no nos llega un combo card, no nos llega una tarjeta donde dice que puedes viajar y que sirve para trabajar. Nos llega el permiso de trabajo y nos llega unos papeles como una advance parole. Em, tienen la misma utilidad, más no son las mismas formas. Esas dos formas son gratis en el proceso. USCIS no cobra por esas formas cuando estás haciendo ajuste de estatus. Y sí puedes salir si te llegan a aprobar el, el combo card o el advance parole.
I'm gonna read this one because I feel like it's a few questions here. Okay, Loruama dice, tengo DACA, salí del país con advance parole en agosto del 2015, creo que está diciendo, o agosto 15 de este año. Tengo una petición pendiente 130 de mi papá, es USA Citizen y me pidió desde el 2004, con fecha de prioridad febrero 2005, hija mayor de 21 casada, ¿ok? tengo un hijo que es autista y va a cumplir 21 años en diciembre del 2025, ¿ok? Estoy casada legalmente. Mi pregunta es, cuando él tenga sus 21, él puede pedirme. Arreglaría a mi esposo si él no tiene ningún estatus legal. Y si no puede, ¿cómo él podría beneficiarse de un estatus legal? ¿Dónde quedaría la petición? Ahí se cortó un poco el comentario, pero vamos a seguir con lo que tenemos. Am, el caso de que su papá la pidió con fecha de prioridad de 2005, eso sería un proceso consular. am, y creo que a ver, eh, está cerquita, creo que la visa bulletin, dependiendo de su país, ¿verdad? Pero voy a enfocarme en su hijo. Cuando su hijo cumpla 21, él la puede pedir. Usted tiene su entrada legal a través de la P que hizo y él la puede pedir. Y usted va a poder hacer ajuste de estatus todo adentro de los Estados Unidos. No va a tener que pedir perdón, no va a tener que arriesgarse a salir de los Estados Unidos como lo va a tener que hacer con la petición que le tiene su papá. Mi primer sugerencia sería espere que su hijo cumpla 21 y hágalo a través del ajuste de estatus. Ahora, para su esposo, cuando su esposo, cuando su hijo cumpla 21, lo que él debería hacer, aparte de pedirle a usted con ajuste de estatus directo, todo el paquete completo, debería aplicar para el papá, pero solamente el 130. ¿Por qué? Porque el papá no tiene entrada legal y no tiene estatus legal. Creo que no tiene estatus, entrada legal, porque aquí no mencionó si él tiene o no tiene, pero asumiendo de que él no tiene. Am, lo que va a querer hacer, como le digo, el hijo va a querer someter el 130 para el papá, solamente el 130 para él. Para usted se puede someter todo, para el papá solamente el 130. Lo que va a ocurrir cuando ese 130 esté aprobado, cuando el 130 esté aprobado, usted probablemente ya va o va a tener ya la residencia a través de su hijo o ya va a estar cerca de tenerla, ¿ok? Lo que va a pasar es, después de que el 130 esté aprobado y usted tenga su green card, usted le va a servir como un familiar que califica para que su esposo obtenga el perdón, ¿ok? Su esposo va a tener el 130 aprobado a través de su hijo y va a tener el perdón aprobado a través de usted, porque usted es el cónyuge, ¿ok? Los hijos no nos pueden calificar para los perdones, los cónyuges sí. Y usted va a tener un caso bien fuerte para el perdón porque tienen un hijo con autismo. Usted va a ser la familiar que lo califica, pero también puede mencionar la situación de su hijo para que su esposo tenga el perdón. Usted va a poder hacer ajuste de estatus adentro de los Estados Unidos. Su esposo sí va a tener que hacer proceso consular, dado que estoy asumiendo que no tiene la entrada legal, pero usted le va a poder calificar para el perdón. Sí tiene que tener cuidado de que su esposo no tenga otra inadmisibilidad que cause de que no le vayan a aprobar la visa cuando él vaya a la entrevista consular. Póngale ojo, cargos criminales, ¿tiene algún historial criminal? No, perfecto, chévere. Tiene múltiples entradas su esposo. Él entró a los Estados Unidos, no importa cómo entró la primera vez, pero entró a los Estados Unidos, se quedó aquí un año o más y luego salió y entró otra vez. Eso es lo que no queremos ver. Ahora, si su esposo entró y nunca se fue desde que entró, no es una preocupación. ¿Ok? Am, Aparte de esas dos cosas, mientras su esposo nunca ha dicho o ha declarado que es un ciudadano, esa es la única otra cosa que puede causar am, algún tipo de que le nieguen la entrevista consular. Y la otra cosa que es algo un poquito más reciente es, mencionó su hijo que tiene, su hija, perdón, no, su hijo que va a cumplir 21, pero no sé si ustedes a lo mejor tienen otros hijos mayores que ustedes se trajeron de su país. Si es que tienen hijos mayores que ustedes se trajeron, van a querer tener un perdón ya listo para eso también. El de haber traído a alguien indocumentado, haberlos entrados al país o haber pagado para que alguien lo entre. Pero si eso no es su situación, no se preocupe. Pero lo más importante, como le digo, su hijo va a poder pedirlo a usted a través de AOS porque tiene su entrada legal y a la misma vez que meta la 130 para su esposo, solamente el 130. 130 es súper fácil y simple, usted lo puede hacer sola, no necesita abogado. Pero cuando ya se apruebe el 130, le recomiendo que agarre un abogado para el proceso del perdón y el proceso consular para su esposo. Pero los dos van a tener camino a la residencia. Mauricio says, thank you. One more question. My U.S. citizen wife is the petitioner, but we will be using a co-sponsor. Does the petitioner on Form I-864 refer to the co-sponsor on Form I-864 Part 4 or the whole application in general? The petitioner does not mention the co-sponsor at all on their I-864. Your petitioner is going to file an I-864 and they're going to mark off that they are the petitioning sponsor. And then your co-sponsor is going to fill out their own I-864. And on theirs, they're going to put down that they're the only co-sponsor. Neither of them mention each other in either of their 864s.
Silvia Martinez says, thank you so much for making this live. I'm recently DACA and I just got my AP in October, but my daughter will be turning 21 in March next year. So far, I had checked and think I'm good to apply to my AOS, but at this moment, I am working with no pay stubs. Is this will be a problem? And the other question is that I was married, but as far as I know, my divorce will be finalized soon. Is this a problem? uh with you not working, or with you not working with no pay stubs, we'll have to check who's your sponsor is. If it's your daughter and she has enough income, then and you have the evidence, like I said, 3 years of tax transcripts, the last six pay stubs, and she has enough income, that you are good. If not, you will have to find a co-sponsor because you will need the pay stubs. Also, um, as far as the divorce, I don't see any problem because she's petitioning you. She's not petitioning anybody else, and if she's petitioning your another person, they will have to go into another form.
Yep. Okay, I'll take this one. Chelly says, so can DACA recipient slash beneficiary slash sole provider be his own sponsor? We have oils filed jointly for taxes. No, you can't be your own sponsor. What you can do is you can combine your income with your petitioner's income. And again, even if your petitioner's income is zero, zero is still a number. Okay? So if your petitioner is has zero income and you have $50,000 of income, your household combined income is 50,000. So you can't really put, be your own sponsor. You can't file your own 864 on your own, but you can combine your income with your petitioners, regardless of whether that number is zero. What you can do on your own is if you have your 40 credits, then you can file 864 W, and then your petitioner's income is relevant. You don't even mention an 864. So those are the two options you have.
Jose Perez says, I had an approved I-130 before, and the case has been closed due to not going forward with consular. Now that I've done AP and trying to do AOS, when the filing out Part 4, Item 10, has anyone else filed a petition for the beneficiary? Do I put yes because of the previous application? Yes, you do put yes. Also, I would suggest you contact the NBC. You put no? You put no, I can't see you, Natalie.
I think sorry, you. I think you're confusing
I don't
that
know.
question with the one at the end. I think that's what's
Mhm.
happening. So the beginning question, the one that he's saying in part 4, item 10, that one is if anyone else has ever filed a petition for the
Mhm.
Oh no.
beneficiary.
So no, no, it's
So
no.
that question, yeah, that question you answer no because it's asking specifically if other people have petitioned for them. But I know Luisa, I know which question Luisa is referring to. Luisa is referring to this. It's almost a very similar question. It's at the very end of the I-130, and it asks if the petitioner has ever filed for anyone before, and that's where you put yes because you have filed, even if it's the same beneficiary, you have filed for that, for a person before. If it's the same, it's still the same person, but you still filed for them. So in that one, you're going to put yes. You're going to fill out the beneficiary's information. You're going to fill out the date that you filed it, and then you're going to fill out the end result, which for you the end result would be approved. It was approved. You can put approved, and then you can put in parentheses later terminated by NBC. Um, but yeah, I think Lisa, you were still right. You were just confusing the two questions. Evelyn Castaneda, how to properly answer question number 26 under a 485 form when only had traffic tickets for no driver's license and speeding. The question asks, have you ever committed a crime of any kind, even if you were not arrested, cited, charged with, or tried for that crime? So, um, keyword is ever, right? Um, number questions 25 and 26 kind of go hand in hand for the 485. Usually if you answer yes to 25, you're going to answer yes to 26. That's the easiest way to go about it. Do we understand that driving without a license and speeding are super, super small traffic violations? Yes, we are fully aware of that. USCIS is fully aware of that. But you likely answered yes to 25 because that question asks about citations. So you're likely going to want to answer yes to 26, but you can provide the same explanation for both of those at the end of your form. You can literally you don't even have to use another space. You can literally, when it says item number, you can just put 25 and 26, and then you can provide your explanation. As long as neither of those tickets was $250 each, you don't have to provide any supporting evidence. You just give them a very brief description. In the past, or if you know the year, in 2020, I was cited for driving without a license and for speeding. Since both of those, neither tickets were over $250. Since then, both tickets have been fully paid. That answers all the questions they may have about those tickets. All right.
Kenya says, had an approved info pass and came back this week. One entry. I also received dental work that needs continued treatment. Can I send AP for dental, but also start my application for AOS? What I would do is start your application with AOS, send your I-130 under your AOS, and try to expedite with that one I-131. Um, so I would send my AOS package with the I-131 and try to expedite that I-131 instead of paying for the I-130. I think both of them will take almost the same time frame if you apply under DACA or apply under AOS.
You'll skip my question. Wow.
I didn't see her question.
I
Did
didn't
you
I
guys
did
either.
hear?
too.
I see the your, and then I see a question, a comment that's blank. Maybe it's the
Yep.
blank one.
I think
Ay,
this is
ay,
a
ay.
follow-up question.
Muchas gracias por contestar mi pregunta, se lo agradezco mucho, pero ella solo lleva trabajando un año y hace entre 23,000 a 25,000 al año. Ok. Silvia, si su hija no tiene ningún depende y su hija no está casada, y su hija no tiene hijos, no tiene ningunos hijos, lo que ella tiene que ganar tiene que ser para usted y para ella, son para dos personas. Actualmente ese número serían 24,650 y ese número es antes de que le tomen taxes. So, si ella está ganando 25 al año, va a tener que hacer unas cálculas en los pay stubs. Si ella está ganando 25 al año, es suficiente lo que ella ganó, ¿ok? Ahora, de que ella esté trabajando solamente un año, eso no importa. Si ella no trabajó en el 2021 y no trabajó en el 2020, ella no tenía el requisito de hacer taxes y eso está bien. Lo importante es que si ella tuviera el requisito de hacer taxes, que los hizo. Pero si ella no tenía el requisito, ella simplemente tiene que hacer una carta y la tiene que firmar explicando la situación. Puede ser bien simple. Mi nombre es, no sé yo, mi nombre es Carla. En el año 2020 y 2021 yo era una estudiante en la Universidad de Washington y yo no tuve ningún ingreso, dado a que no tenía ingreso, no tenía el requisito de, de hacer impuestos federales y por esa razón no tengo impuestos federales para el 2020 ni el 2021. Empecé a trabajar en el 2022 y ese es el primer año que yo he hecho impuestos. Lo que ella va a tener que hacer es hacer esa carta, firmarla, incluirla como un comprobante y lo que sí va a tener que hacer es en el formulario, la página 5, la pregunta 24A y 24B, le va a pedir de que ella ponga los años y el ingreso. Ella lo que va a poner ahí es el ingreso, cero. Va a poner, o mejor todavía, ponga no aplicable en el año y en la otro espacio donde tiene que poner el ingreso, que ponga please see last page, o sea, que miren la última página. También hay una cajita después de eso, a donde la cajita dice que le haga, marca la cajita si es que ellos no hicieron taxes porque no tenían el requisito de hacer taxes. Ella va a querer marcar esa cajita. So va a querer poner eso en los años que no hizo taxes, que no hizo, va a querer marcar la cajita y yo le recomendaría también que al final del formulario, en la página, en la última página, la sección de información adicional, que ella dé también esa breve explicación. Yo no hice impuestos el año 2020-2021 porque era una estudiante y no tenía ingreso y no tenía el requisito de hacer taxes. Por favor, encuentre adjunto a mi aplicación una carta de explicación y mis comprobantes de mis taxes 2022 y de mi ingreso actuales. Acuérdese de que ellos no hacen la decisión en basado en el ingreso de que ella tuvo en los otros años, sino el ingreso actual. ¿Ok? So, igual ella lo puede hacer, pero solo ojo que tiene que ganar 24,650 o más. So, chequea ahí sus colillas de cheque y vea si está ganando eso.
It
Itzel
says,
says, oh, go ahead.
I'm pending a PIP approval. They just requested an updated ID card of my spouse and will be submitting AOS ASAP. Now, my question is, can I expedite my AOS as he will be employing this upcoming year? Yes, you can. You can go
Mhm.
ahead and expedite.
You definitely can. Once you have your AOS submitted in there, um, I would go as far as USCIS really gives a lot of leeway to military members. And sometimes I have even seen people schedule an info pass um, and go with their petitioner in uniform and with their deployment orders and show that in person. And sometimes your local field office may even look over your case really quickly and adjudicate on the spot. Okay, so that doesn't mean it's always going to happen, but you do have the opportunity to apply for expediting. A lot of people will say you can't expedite the 485. Technically, you can expedite any USCIS form. The question is it worth to expedite if you know that you're not going to get it, right? In your sense, you definitely have a viable reason to expedite 45 because it is in the best interest of the United States. That's the key word there, guys. They don't really care if it's in your best interest. It's in the best interest of the US. Why is it in the best interest of the US? Because your spouse is a military member and they will be deploying next year. So if they can make it easier for your spouse to stay with their family member, then that makes it easier for the US as well. So that's kind of the route that you want to take. Okay.
I will add to that she can put it on the cover letter, military
Mhm.
spouse. So that way they know right off the bat that that's a military application or like a military derivative application because on the joint sponsor is asked that question as well.
Oops.
Code.
Thank you. ¿Cuánto debo
¿Cuánto debo
ganar?
ganar para no ocupar un sponsor? Yo voy a decir que esa es la pregunta dependiendo de la cantidad de personas que estén en tu household. Dependiendo cuántas personas sean miembros de los que viven en tu casa, de eso va a depender. Yo siempre digo, puede ser tan poquito como 25,000 o tan mucho como 50,000, porque 50,000 es cuando ya puedes tener más personas, 5 personas o más, y ya puedes ser el sponsor. Todo depende de cuántas personas. tengas en tu caso.
Lo que puede hacer es ir al sitio de web de UCIS y busque 864P, P de como Pablo. Y ahí va a estar la tablilla a donde usted puede mirar el size del tamaño de la casa o del hogar y cuánto es lo que debe ganar. Tiene que mirar al lado que dice 125,000, a lo menos que el patrocinador es un miembro del militar, entonces es menos, pero generalmente para todos nosotros es 125,000 eh, del monto de pobreza federal. Thank you, Sarai.
Okay, so Grace says my petitioner would be my daughter. She works part time. I have my 40, I guess, credits. However, there is a gap of 1 month of my DACA during COVID. Will this be a problem? Okay, so I think there's two questions here. Um, if you're gonna go ahead and use your 40 credits, I will if I were you, I would make sure that I do have all the years that I'm supposed to have and that they all qualified. Also, I will send on my employment authorization cards proving that all the years listed I have been able to work authorized. Um, with that 1 month of DACA, there's no problem because I guess there's no way for you or for them to prove that that month you were not there, since usually it's per year. So
And
I don't know.
un unless all of your income from that year was from that 1 month that you were without DACA, then that's where it'd be an issue, right? But most of the time we earn enough where even if you grab your income and you divide it by 12 and were to reduce the amount that you got during that 1 month, it's still gonna be enough. And they're not even gonna go ahead and do all that math. They just wanna make sure that for the majority of that year, you were employed, and you were working authorized and your income was authorized. So it shouldn't be an issue either way. Okay. Berenice, for Form I-765 and I-131, all we need to attach is the beneficiary's two passport pics, correct? I also tend to attach an identity document like a passport, and I tend to attach proof of your most legal entry so that they can see your code of admission, class of admission. Now, the reason that I do that is because the USCIS officer that adjudicates your adjustment of status and your I-130 petition may not be the same USCIS officer that adjudicates your I-131 and I-765. So you just want to make sure that they have the necessary evidence, even if your case gets split up like that. So identity document and the proof of legal entry is what I would attach.
Silvia says, sorry, I have so many questions. But how much you guys charge to fill out an AOS for us? I would suggest for you to get a consultation, and we will go over all that information with you during that consultation. There, you have one-on-one with us, and we will either see your case and see if we can take it. It has many determining factors about your case. So we cannot give you a price until we don't see your case and determine if we can go ahead and take or not, or suggest you to go to a lawyer. So book a
Our,
consultation.
our consultations, guys, are our consultations are $75. So just go ahead and book an appointment. You pay $75. That $75 does get credited towards your total amount due for the legal services. But I do just want to add on because I know sometimes it sounds a little funny. It's not like we hear your case and we that minute decide like, oh, this case sounds really hard, so we're gonna
No.
charge you this much. Your case sounds really easy, so we're gonna charge you this much. We have set fees for different types of cases. And so when we ask your questions, we're able to determine what kind of case you have. And then that way we can look at our fee table and say, okay, this is the fee for this legal service. Each legal service has its own fee. So that's what we mean by we need to hear your case. Not just to figure out how much your legal service fee would be, but also to figure out if you're within our scope, what we handle, and if you're even eligible for adjustment of status. Sometimes we find we have consultations and we know people are going to be needing to fix a few items first. And so we tell them, you know what, you need to fix this first. You need to maybe amend your taxes first. And then once you get that done, come back and we'll be happy to take your case. So just want to let you guys know, it's not like we just make it up. There is a fee rates, but it's it just depends on your case, right? We can't charge um somebody who has to do a whole AOS case the same as somebody who just has to do like the 45 and not the I-130. So that's what we mean. But again, our consultations are super, super affordable. It's $75. It does get credited towards your total price. So just book a consultation. We'll talk to you. We'll ask you a ton of questions. It's almost like we interview you. We'll ask you a ton of questions so we can figure out the details about your case and whether we can take you on, and we'll explain everything to you then.
This is a follow-up question. So I don't know if you remember him, but he said that he was petitioned
Um,
for his U.S. citizen parent before he turned 21 back in 2004. And he's doing waiting
okay,
for his AP.
got you. Osvaldo, question for you. Were your parents US citizens when they petitioned for you back then? Or were they legal permanent residents and then became US citizens after your petition? So I guess my question here is, how old were you when your petitioning parent naturalized? Right? How old were you when that happened? If your petitioning parent was if they naturalized or if they became US citizens officially before you were 21, your age was frozen at that time. So in USCIS's eyes, you're still under 21.
Okay, I
Um,
just went down all the comments and he says that they were US citizens. So,
when he was under 21.
mhm.
Okay, so then you shouldn't have a family preference category. You should still be an immediate relative petition. Um, so you really shouldn't have to wait for the visa bulletin. I would suggest that you go onto the USCIS website and look up CSPA, which stands for Child Status Protection Act. Um, and there's like these little calculators that you can use. You're gonna need your age. You're gonna need the priority date from your I-130. And they'll tell you whether the CSPA has frozen your age at 21. But usually, generally speaking, if you were under 21 and your parents were US citizens when they filed for you, your age is frozen. Like it's pretty much frozen forever. You're still considered under 21 now as long as you're unmarried. So definitely look into that because at that point you're still considered an immediate relative and you can just do adjustment of status. There's no need to keep waiting. I guess if you need a legal entry, that's the only thing you may be waiting for. Okay, we're gonna finish this up with these next couple of questions because it's getting late.
I was going to say thank you because I didn't look online. Okay, this is easy one.
Does USCIS always notifies you when they transfer your case
Nope.
I-485 to your field office? No, they do not. They work on their time and they proceed as they think they proceed. So, no.
Sometimes they let you know, but most of the time they don't.
Don't wait for that answer because I don't think you're. Hey ladies, how safe is to travel with my combo card? My husband and I are a little hesitant to use it as the letter says that if you accumulate unlawful presence for more than a year, I guess as you are admissible for 10 years. He obtained DACA when he was 20 years old. Um,
So if no, no, go ahead. Go ahead.
Go ahead.
Well, I was gonna say that there is a BIA case, Board of Immigration Appeals case that actually set precedent for this. If you are traveling with a combo card, they do not count that travel as a official departure. So it doesn't trigger a 10-year bar when you leave. Now, what is unsafe with traveling with the combo card is, of course, if you're doing something you shouldn't be doing, transporting things you shouldn't be transporting. But to be very transparent with everyone here, something that is not spoken of enough is that if you're traveling with a combo card and you have an iffy case, I would suggest waiting until your green card is approved because if you are abroad and your AOS case is denied, your combo card is immediately voided. It's no longer valid. Okay. Now, that really is only a risk if there's no one in the States that's getting your mail or you don't have access to a USCIS online account. Why? Because they will first send you a RFE, which is a request for evidence. And sometimes they'll even go as far as sending you a NOID, which is a notice of intent to deny. Okay, now if you have an RFE, don't travel abroad with your combo card. If you have I'm sorry, if you have a NOID. If you have a NOID, do not go abroad with your combo card. You have an official notice of intent to deny. Your case is at risk of being denied. You don't want to be abroad when that happens, okay? But always make sure that you have access to your case online or you have someone checking your mail when you travel abroad so that you're fully aware of your case status while you're abroad, okay? Would I know if I fall under 245I by searching via FOIA or USCIS? Yeah, you're going to want to submit FOIAs to USCIS in order to search for 245I. But if you're searching via derivative, make sure that you're the person who should be submitting that FOIA should be the petitioner if they're available. Marisol dice, a mi papá lo pidió su empleador cuando toda la familia, pero a mí me negaron mi petición porque ya estaba casada, pero tengo la 245I. Eso quiere decir que mi esposo tiene la 245I ni mi hijo puede hacer la AOS. Ok, pero en el momento, bueno, dice que su papá, creo que me está diciendo que usted era una derivada de su papá, que significa que en el momento que él fue aplicado por un empleador, usted era menor de 21 y no estaba casada en ese momento. Si es que usted no estaba casada en ese momento y era menor de 21 en ese momento, usted tiene la 245I, porque usted es una aplicante derivada. Su esposo no tiene la 245I, porque ¿cómo explicarle? Usted no fue la aplicante, usted no fue la persona por cual se aplicó. Su papá fue la persona por cual se aplicó. Entonces, los familiares directos de su papá tienen 245I, que sería el cónyuge de su papá y los hijos menores de 21 de su papá. Usted no tiene 245I directa, usted tiene 245I indirecta, ¿ok? Eso significa que su esposo tendría que haber tenido 245I aparte. Él no puede, no puede no puede obtenerlo indirectamente de usted porque usted nunca tuvo una aplicación directa. Usted fue indirecta a través de su papá. Ahora, una de las cosas, ay, perdón, una de las cosas que sí puede pasar, y aquí es a donde estamos en un área un poquito gris, y le recomendaría obtener un abogado con bastante conocimiento de 245I, como el abogado Charles Tuck, es que a veces permiten de que la persona que tiene 245I, irrelevante de que si es directo o indirecto, se ajuste con su pareja y sus hijos, si es que su petición lo permite. Por ejemplo, si usted ahora está tratando de ajustar a través de empleo a donde le permiten derivados y usted tiene 245 y a veces su esposo o esposa puede ajustar con usted. Pero si usted tiene una aplicación a donde es un hijo mayor de 21 que la está pidiendo, entonces no tiene derecho a derivados y no puede hacer eso. Pero para su situación, yo me dirigiría a un abogado que tiene bastante conocimiento de los 45I.
Ok, Claudia dice, si
Correcto,
una persona se declaró ciudadana americana falsamente y tiene 245 y de todas maneras no podría hacer EOS por su respuesta, gracias.
correcto. Si el 245I no perdona haber declarado haber sido ciudadano americano.
Yo apliqué por medio del trabajo con la 245I, pero se divorciaron mis patrones y me despidieron. Pero después me fui con la ex esposa de mi patrón y ahí ya llevo desde el 2008.
2008.
Pero ya no seguí el
Pero
caso.
no seguí el
Mi patrona
caso,
está dispuesta a
pues
peticionarme.
a
Mi
peticionarme.
pregunta es, ¿podré arreglar cuando mi hijo cumpla 21? Él tiene 17. Ahora mi esposa tiene DACA y apenas hizo su AP y regresó. ¿Ella puede arreglar por medio de mi hijo? Gracias.
Su esposa, dado que ya tiene su AP y tiene su entrada legal, puede arreglar a través de su hijo cuando el hijo cumpla 21. Usted, si tiene comprobante de que sus empleados le sometieron esa aplicación antes del 30 de abril del 2001, esa es la fecha clave. Am, entonces usted puede usar eso para que su hijo lo patricione si es que usted no tiene entrada legal, porque la 245I le perdona no tener una entrada legal, pero quiere asegurarse de usted tiene la responsabilidad de someter la evidencia y comprobarle a UCIS que tiene 245I. So tiene que tener el papeleo para eso. Lo que va a querer buscar es un comprobante de que se sometió o un I-140 o un certificado de labores al departamento de labores. Cualquiera de esos dos le serviría.
Okay, dice, if my husband and I don't file tax together, can we use my income to do AOS and have all the credits?
You're mixing up two separate things here. Income and credits are separate. You either have the 40 credits and you file 864W, or you have the income and you file 864 regular. Even if your husband and you don't file taxes together, you can still combine your income and do the 864 via combined income. For the 864W, you would have to prove that you have 40 credits. So those are two separate things. The
Now,
income and the credits, two separate things.
I would add that if you guys are filing not together, make sure that you guys are filing married, filing separately. Other category, it will not be accepted. Are we able to use assets to make up the income missing?
Yes, there's some rules to that, and it's also not the simplest way to make up missing income. So I would suggest that if you have the ability to get a co-sponsor, that you do that instead. But if you have no other way of meeting those income requirements, then you can use assets. I believe you have to show because if your petitioner is a U.S. citizen spouse, you have to show 3 times whatever is missing. So if you're missing $5,000 to meet the federal poverty lines, then you have to show 15,000. If your U.S. citizen petitioner is your child and not your spouse, then you have to show 5 times as much. I see you have some follow-up questions here.
Mhm.
From home equity, can we send a comparative market analysis? No, they want to see the value of your home. You can pay somebody to give you a valuation of your home, or you can use the valuation that the county or city does of your land and property. Um, my husband was 9 years old when coming to the US in 1996. He says he remembers he wasn't fingerprinted or anything. Is he able to do AOS? He already got his AP. Um, I mean, it depends on what he remembers. If he came when he was 9, he should remember a decent amount. So I would ask him how he came. Like, did he come crossing, the El Rio, crossing through land? Did he come in somebody's car through like a border crossing? Those are kind of the things you want to figure out. As long as he had no interaction with CBP, nobody asked him anything, nobody, he never presented any documents or anything, then he should be okay. But if you're unsure, we always say if you're unsure, do a FOIA. If you're sure that you had nothing, then you're good. But if you're unsure, do a FOIA. Okay, I think we're gonna maybe do 2 more questions and then we're gonna close it out because it is late.
Okay,
Claudia dice, oh, dale, dale, dale. You're good. Go ahead.
Claudia dice, hola, yo tengo DACA, yo ya tengo entrada legal, ya tengo una entrada con Advance Parole, mi hija es ciudadana, va a cumplir 21 el siguiente año. ¿Yo sería elegible para ajuste de estatus? sí serías elegible para ajuste de estatus, tendrías que mirar que solamente tengas una entrada, em, y que solamente tengas una entrada y no tengas varias entradas que haga un trigger para una permanent bar. Creo que es lo único que.
Mhm.
Ok.
I guess
Yo
we
want
can close with Renita Leon's comment.
por
Says,
fin.
por fin aprobaron la residencia de mi esposa. So,
Felicidades. Okay. So aquí vamos a cerrar. This is where we're gonna close out everyone. We may have a few questions left. Very sorry. We will try to get to them in the comments tomorrow or Monday. But we appreciate everybody coming on and asking us your questions and listening in to what we have to share. We will be try to be doing more lives at least once a month if we can fit them into the schedule. Um, Please don't forget if you would like to book a one on one for any of our services, AP, if you would like a consult for us taking your case on for adjustment of status, if you would like to receive our services for DACA renewal, visit our website, dreamerstogether.org, and you can see the list of services and you can book an appointment if you need to. Other than that, we hope to see you guys in our Facebook groups. All the information is there. Take care. And
thank
you lovely
you.
ladies, I hope
Bye.
you have a good night.
You
You
too.
Bye.
too.
Bye.